Hello friends, for AIB 18 exam and all law exams, the case laws are asked and we just want to get sure about we should get the full marks in this also. So these are the leading cases in Indian Contract Act 1872. This is useful for AIB, LLB, BLLB, JMFC and will continue at least 10 minimum cases every day. So we'll go for Contract Act first. The basic of contract will go for the slide first. These are the basics of contract. Offer is the first step. Acceptance of the offer, and the parties must be competent to enter into contract above 18 years, and the minor are not capable to go into contract. The minor contracts are invalid. As you know about the Mori Vivi case, it's very famous. Fourth, there must be a consideration which is to be lawful in nature. Unless there is a consideration, the contract is not valid. Free consent of the parties. Free consent is necessary. Unless there is a free consent, the contract is not valid. A forcible, whatever the criminal intention, the contract will be invalid. 6. Intention to enter into legal relationship. So the leading case is Balfour versus Balfour in this case, where there is no legal relationship. The husband and wife, they have just wife go into court for the recovery of the maintenance. 7. The contract enter into must be certain. And 8 is the contract must not be expressly declared to be void. We'll go into second. The first case in this, as I said, it is about the Balfour versus Balfour 1990. 1919 case आहे. The case of Balfour versus Balfour of legal reaction theory in contract law. Mr. Balfour वरती Mrs. Balfour wife नी केस केलेली होती. And a legal reaction theory in contract law, Lord Justice Atkins observed that agreements that are made between a husband and wife, a contract cannot be enforceable by nature if the parties to the same do not intend to create legal relation with each other. Second case is Lalman Shukla versus Gauri Dutt in 1913. The leading case has the importance of knowledge and communication in the formation of contract was highlighted by the Allahabad High Court in the landmark judgment of Lalman Shukla versus Gauri Dutt. Third case is of Ramsgate Victoria Hotel versus Montefiore. In the case of Ramsgate Victoria Hotel versus Montefiore, 1866, the Court of Exchequer discussed the revocation of an offer that resulted due to lapse of time. Fourth case in this is Harvey versus Passy. It is 1893 leading case. The difference between an invitation to offer and offer has been laid down by the Lord of Judicial Committee of the Privy Council on the appeal case of Harvey versus Passy. Invitation to offer आणि offer मधला फरक केलेला आहे. Fourth case, Pelthouse versus Belday, 1862. The concept of acceptance was taken up by Court of Exchequer Chamber, the UK, in the case of Pelthouse versus Bindley. Pharmaceutical Society of Great Britain versus Woods Cash Chemist, a 1953 case. The case of Pharmaceutical Society of Great Britain versus Wood Cash Chemist revolves specifically around the concept of invitation to offer. Mori Bibi versus Dharmodas Ghosh, 1903. Mori Bibi ambit of minors agreement in the well-known case of Mori Bibi versus Dharmodas Ghosh, the case where the plaintiff and the defendant had entered into mortgage deed, the same was held to be void as mortgage execution was carried out by minor as individual. Donoghue versus Stevenson. The doctrine of negligence was laid down of Donoghue versus Stevenson case. In the case, the injuries that were caused to the plaintiff from the defendant's defective products. Applying the neighbor's principle, the court rules out that the defendant did owe a duty of care to the plaintiff. Duty of care. Bhagwan Das Kedia versus Girdhari Lal and Company, 1959 ची case है. The Supreme Court of India, while deciding the case of Bhagwan Das Kedia versus Girdhari Lal and Company, 1959, took into the account of Section 2, 3 and 4 of Indian Contract Act 1872. And the last case in this video is Phillips versus Brooks, 1959. The issue as to whether a mistake to identify essential of a contract ipso facto makes the contract void or not come before Judge Horridge of the King's Bench Division in the case of Phillips versus Brooks. We'll continue 10 more cases tomorrow, and possibly I'll take it from the already solved papers of IAIB, so that will be helpful to us. Please like, share, subscribe. Thank you. We'll continue tomorrow.